The Karen Reed trial, we watched it together here, gavel to gavel, for 9 weeks with jury selection. It was 10 weeks of trial. At the end of that trial, the jury was unable to reach a unanimous decision, and they told the judge that they were unable to reach a unanimous decision. They were not polled. The judge did not ask. There were no further questions. And I have broken down the judge being like, they said further deliberation would not be helpful. And the judge was like, and I'm not going to ask you to do that. I'm declaring a mistrial. Thank you, ladies and gentlemen. You can go. And it was moments. The jury was in the courtroom. The jury was out of the courtroom. It was like, whoom, bye. But this came on the tail of the jury sending out multiple notes saying that they were unable to reach a unanimous verdict, and the judge giving that much stronger bump to the jury, the Tui-Rodriguez instruction, as it is called in Massachusetts, which is a try to reach a decision. No jury is smarter than you are. No one's going to have more information than you do. You might want more to come in, but there is nothing else. You have what you have. Let us know. Go back and try one more time. After the mistrial was declared, the defense started getting jurors reaching out to them proactively and saying, hey, here's the confusing thing. We actually reached a verdict on 2 of the counts, and we were stuck on count 2. We reached verdicts on 1 and 3, and we were stuck on count 2, and like nobody asked us, and we don't know what to do with that. Thought somebody should know. After the defense got that information, the defense put together a motion to dismiss and affidavits. The defense argument in that motion to dismiss is essentially Karen Reed was acquitted on 2 counts by the jury. So the defense was arguing because the jury in fact reached verdicts, even though they weren't on a verdict form, they're verdicts. And because they're verdicts, she cannot be tried again on counts 1 and 3. Counts 1 and 3 are the counts that require more volitional action, intentional action. Count 1 being that homicide count, count 3 being the hit and run causing death. Both counts require that Karen Reed knew she hit the victim. And both of those counts require a knowledge element. Some of the lesser included in count 2 get a little different on what requirements there are. And I broke that down in another episode of the Emily Show podcast if you want a whole discussion of count 2 and lesser included. So the defense was arguing, look, counts 1, counts 3 require volition, but the jury came back and we're being told by multiple jurors that they reached a verdict. Therefore, trying the defendant again is double jeopardy. And or let us talk to the jury, and or dismiss the counts, and or there was no cause for a mistrial, therefore you must dismiss the count. So in their motion to dismiss, there were a number of arguments lined out. Their kind of top level argument was dismiss the case. I think what they were really optimistic for is the judge to allow them to question the jurors about what verdicts were reached. I think the defense wanted this because it allows them to then ask the prosecution to dismiss those counts. Look, the jury came back. The jury had verdicts. Do the right thing. It gives them a stronger arguing position for the prosecution. And it allows the public to know, did all 12 jurors reach that verdict? Or is it a handful of jurors that came forward and other jurors didn't? I think it's telling that other jurors haven't come forward to say, hey, we didn't reach a unanimous verdict. Not a single juror has come forward and said that. So the defense knew this was a bit of a Hail Mary argument for the motion to dismiss, with the argument that this would be a violation of double jeopardy. It is not widely accepted in the law that a juror reaching out after a case saying, but we had a verdict, is a verdict. Generally, there must be a verdict form or a verdict slip, and you have to know from all of the jurors. Most of the case law that allows jurors to be asked about verdicts or asked about anything that happened with the jury after the case is concluded, which is where we're at here, has to do with either outside influence or internal bias in the jury deliberations, but you're generally not allowed to get to the jury deliberations for any other reason. So we've seen jurors be inquired of in the Murdaugh case because the allegation there and the finding there was that there was outside influence, and that is still running up the road to the state Supreme Court in South Carolina. So generally, inquiring of the jurors or polling the jury after a mistrial has been declared is not something that there's really a legal path for. It's not something that comes up. It's something that needs to be dealt with before. This jury's been discharged. They have no more legal bearing on this case. So what the defense was asking for was a bit outside, well, with the motion to dismiss, a lot outside of what case law generally allows for. At the end of 21 pages, the court had some moments of snark, but made very clear that the judge was not granting any dismissals and was not allowing for the jurors to be inquired of. The court set forth that there are two circumstances accepted under case law where a jury can be inquired of, and that is issues of bias inside the jury deliberation room and issues of outside interference like we saw in the Murdaugh case. The court says very clearly there is no argument from any of the parties that those two situations are at play. Therefore, there will be no inquiry into the jury, because inquiring into the jury would necessitate asking the jury why their final note said they were unable to reach a verdict on the charges, and yet they are saying they now have verdicts on two of the charges after deliberations ended, after the mistrial was declared. And the court said that that would be getting into the jury's deliberative process, not simply inquiring as to the result. So the court is not allowing further inquiry of the jurors. The court is not granting a dismissal. I imagine what will happen from here is the defense will say we are disappointed in today's ruling and we will be appealing this decision. And the prosecution will say that this ruling is in line with the long history of case law in Massachusetts, and we will be moving forward with the prosecution of Karen Read on all three counts come January 2025. I imagine that that's what both sides will do when they make statements to the media, because the court in many ways adopted the arguments made by the Commonwealth throughout this ruling, and the court made very clear throughout this ruling that they believe the defense had adequate time to object and the defense had adequate time to ask for the jury to be polled, and the defense did not ask for the jury to be polled. The court also said that the court was not going to poll the jury because it might have gone against the strategy of the defense to not poll the jury, and it might have been seen as impermissibly coercive because there was one count that had lesser included counts. And under case law in Massachusetts, the court believes that inquiring as to a split verdict on counts where there are lesser includeds, the cases have found that that inquiry alone is impermissibly coercive by the court. And the court put in a shady footnote saying, and Attorney Jackson had already said that they believed that the court was trying to coerce, and that was not the exact word used, but already trying to imply a verdict with the way the verdict form was written. And the court said because of the objections of Attorney Jackson during the trial, the court was overly cautious not to overstep and not to make any statement about how she thought this should go, or to make any indication to the jury that there should be a partial verdict by asking for it. The jury notes were very clear. And I think that's what's so difficult in this case. And I think that's why the appellate court isn't going to do much with this, because the jury notes said that they had given consideration, that they were deadlocked on charges, that there was nothing that they could do. I don't think that the Court of Appeals will do much with this because they don't want to open up inquiries to juries after the fact. It means that no case would ever be final, and courts like finality. The courts have carved out exceptions for outside influence and bias, and they're not going to carve out a after the fact, go home, think about it more, and be like, we reached a verdict. This is a high profile case. And the courts are not going to want to open a can of worms with whether or not jurors change their mind after going home. The only way to really know if that happened is to inquire of all the jurors, but the court's not going to allow an inquiry of all the jurors. So on this, I agree with the court with regard to the manifest necessity for a mistrial. I agree with the court on that. I think there was room for the court to allow an inquiry for the jury. The court was not so inclined. Clearly. I disagree with that. I think there was room here. I am not the judge. It is not for me to decide. Do I see what law the court is relying on? Yes. Does that law support the judge's finding here? Yes, it does. The law supports the judge's finding here. Do I wish the judge had allowed the inquiry into the jurors? Yes. Do I understand why the judge didn't? Also, yes. Does that mean I agree with it? No. Is it the unusual case that a jury will have reached a verdict and not communicated it in any way? Yes. This is a very unusual result. You will normally see it manifested in some way in the jury notes. What do we do if we reach a verdict on some but not all of the counts? What do we do then? There was no note ever asking that. And with that, the judge, under the case law that we have seen in this order, the judge can't inquire much more than that. And that's on the case law. Could the appellate court look at it and say, you know what, we disagree with the case law. We think polling the jury is maybe the better way to go. Maybe they could, but that's not what happened here. And the judge took every opportunity to say, hey, the defense could have asked and they didn't. The defense could have objected more and they didn't. And it is not my role. This is what the judge is saying in this order. It is not my role to overstep the defense attorney's strategy. And that's on them. And then she took a minute to take a dig and say, and they went out and said that this was a win on the steps of the courthouse in front of the media. And here's a link to the YouTube video. Do I think this will change on appeal? Probably not. Do I think the court could have dismissed this? No. The best the defense could have hoped for here is allowing an inquiry of the jurors. Does that stop the jury from coming forward further? No, it doesn't. It doesn't at all. Does it feel like the just result when the jurors are saying, we had a verdict? No, but we don't know if all of the jurors agree with that because we have not heard from all of them and we're not going to hear from all of them, it seems. Could the jurors say to the Commonwealth, dismiss these cases? I mean, they could. The Commonwealth can choose to dismiss the charges. They seem disinclined to acquiesce to that request, but they could choose to do so. I don't think they will. I don't think it's good for the Commonwealth to hear that these jurors did not agree with counts 1 and 3 and then to decide to go ahead and retry it. Do I think this will change an appeal? I think that would be the unusual result. But yes, the defense can appeal this, and that's where it goes. Will they have time to finish that appeal before this goes to retrial? I mean, we're in August. This is set for retrial in January. Depends on how swiftly the appellate court takes up the issue, or if the appellate court just says, we don't need briefing on this, it's denied. We're not letting you inquire into the jurors. Courts like certainty. And allowing for the jury process to be opened up after people go home, after all the admonitions of staying off the media and everything like that is gone, allows for there to be fuckery after the fact. I'm not saying that that's what I think is happening here. I'm saying that that is the court's biggest concern, is that there can be fuckery with the jury after the fact. And it's why they are very hesitant to open up inquiry into the jury. But I don't think there's any case law that allows the court to dismiss it the way the defense was asking for. That's just the way the law is at the moment. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.